persuaded by the studies that show that in low conflict marriages, sticking it out for the time that the children are at home is ultimately going to be a good for those children.
What advice would you have for a couple? I don't want to put you on the spot on this one, so you don't have to answer if you don't. I'm sure it's an easy one to answer. Is advice to a couple that's a high conflict, obviously, and a lot of them realize that a high conflict case. Well, is there some recommendation in which direction they should pursue if they're getting divorced?
Well, if it's
are there better approaches for them to get a divorce? Adversary, collaborative, mediation, or other things they can do to at least have a. If they can't, I used to say to my couples, if you can't have a good marriage, you can have a good divorce. But is there ways that are making that divorce less conflict, less high conflict?
I think for the high conflict marriage, I think divorce is something that should be on the table. And then the method of that dispute resolution, it's always going to be better to not go to litigation. That takes its toll on everyone, including not just your emotions, but your pocketbook. Mediation has been around now for a long time, and as you know, it's a process that can achieve a resolution without some of the emotional damage that comes from trying to, put on the worst case that one can about the other party in a courtroom. I think mediation has a lot of value. It's not going to be successful for every couple. I think from the mediator's standpoint, most mediators try to get the couple to focus on the future, and I'm talking really about mediation for child custody, not mediation for economic issues, which is also a very good thing when that happens. But for child custody, which tends to be the most rancorous part of a divorce, mediators are very helpful in getting couples to see that their past battles are not something that needs to be fought at, in the present, that they really should focus on the future and try to figure out what's going to be best for the children. And one thing that seems to me that's going to be a good thing for children is to not be dragged through several months of litigation.
That's good. Back to the children, but I also wanted to ask you a few other questions before we run out of time. And one of the things that I find with a lot of couples is that they get confused over what law applies. And there's almost a sense, maybe from watching movies and other things, there's sort of like a national divorce law. But there isn't a national divorce law, is there?
No, there isn't. In this country, the 50 states are often referred to as 50 laboratories. Each state is basically its boss in terms of how it wants to structure divorce law and marriage law. And you have some states, 2 now, having the power to say under their state constitutions same-sex marriage is required. Other states are free to disagree under their own laws. And it doesn't mean, though, that the federal government can't get involved in marriage and divorce regulation. It does so in sort of indirect ways. One is through child support enforcement. The federal government can impose conditions on states to live up to their standards, the Fed's standards, in order to receive federal funds in running their child support programs. And that's really the vehicle for a lot of federal legislation right now that requires, for 20 years, has required states to improve their child support standards and their enforcement mechanisms if they want to continue to receive federal funding. So it's not completely a walled-off spectrum of just state law.
But there are certain states, with the base. Sorry about the cold.
Sorry too.
And in some states, for instance, require fault to get divorced. Still, some states don't.
Right.
Alimony laws seem to vary tremendously from state to state, and it seems almost arbitrary that depending on where you lived, it may depend on what the results of the divorce case are.
Well, that's really true, and that may seem arbitrary, but other people think it's sort of the beauty of living in the United States, with each state being its own sovereign with respect to certain things. Divorce law is very different around the country, and New York still has the most difficult divorce law, the most onerous in terms of imposing requirements on the couple, on a person who wishes to divorce. It does not yet have no-fault divorce, and a couple, if one party wants to divorce in New York, basically that party must establish fault on the part of the other spouse before the divorce court is going to be open to that person. And that's some people think that's a good thing at this point, that we have we've gone to the other end of the spectrum in relaxing divorce laws. Since we think we know that marriage is a good thing, why have we made it so easy for divorce to occur? So that's why right now there's a debate in the New York legislature about whether to improve, some say, its divorce law by loosening it, and others say, wait a minute, why would we make it easier for New Yorkers to divorce?
It seems to me even what's defined as property. I had a case years ago where the people lived in Connecticut and New York. What was defined as a marital asset was about a $20 million split in assets.
Well, New York is also the state that's famous for holding one spouse's educational degree is considered marital property, and what New York courts do is to put a price tag on that degree, like a law degree, at the time of divorce, which is going to be end up giving the non-degree holder spouse a piece of that degree holder spouse earnings for some period of time into the future.
As I say, Texas is another interesting jurisdiction. I think Texas may be the only state where you can get a jury trial in some aspects of divorce cases. Interesting case, and also for women.
A few other states also
Can you tell us,
jury
switching
trials.
gears again, can you tell us a little bit about the National Defensive Divorce Act?
The Defensive Marriage Act,
sorry. Not Defensive Marriage, my slip, Defensive Marriage Act.
The Defensive Marriage Act, otherwise known as DOMA, was enacted in the 1990s during the Clinton administration, and it came as a result of fears in Congress when the Hawaii Supreme Court had one of the first cases where it seemed poor to require Hawaii officials to permit same-sex marriage. And it ignited a big movement across the United States. It reached Washington, and Washington responded with the Defensive Marriage Act, which says that no state shall be required to recognize or give full faith and credit to a marriage other than between a man and a woman. And it also says for purposes of federal law, marriage means male and female. It does not mean same-sex marriage. So all the myriad, Social Security regulations, tax regulations, etc., that use marriage as a guidepost, for those purposes, marriage remains male-female. DOMA has also been reflected in some state laws where each state is able to enact its own little Defensive Marriage Act, and Arizona has done that with its own legislation.
Barbara, I want to thank you very much for coming on the show. We could have talked for a length of time. We barely to the surface here of the questions, and I'm always amazed how far we can do. But I want to thank you for being on the show, and if you need more information about Barbara's show, look at the website at the bottom of the screen. And once again, thank you very much. And you've been watching Divorce TV with Wally Marcus.